MSW Media.
So yeah, now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Welcome to episode 220 of Cleanup on Aisle 45/47. It's Wednesday, April 9th, 2025. I'm Allison Gill.
AG, what's up? It's Harry Dunn here. We have a lot to cover today, including one small, tiny bit of Rudy news to close out the show. Rudy. We also have some details in the ruling from Judge Dale Ho dismissing the bribery and fraud charges against Eric Adams.
Yes, and we'll also go over some court decisions on whether Trump's January 6 pardons cover unrelated crimes. And we have an en banc ruling regarding reinstating Glenn Wilcox and Cathy Harris to their National Labor Relations Board and Merit Systems Protection Board jobs, respectively. But first, we have some new patrons to thank. Yeah, so thank you so much. Ben McLevy, Karen Chun, Wendy Whitney, James M. Taylor. I think he puts the M in there, so not to be confused with James Taylor.
Yeah.
Rachel Reed and William Rogers. Thank you so much. We really appreciate it. We couldn't do this without you. And if you've been thinking of becoming a patron, you've been on the fence for a minute, and you can still swing it, now would be a good time. Advertising budgets are in the shitter, thanks to the idiot-in-chief and his tariffs. And we could use all the help we can get from sustaining members. You can join up at patreon.com/aisle45pod, AISLE 45POD. You'll get these episodes ad-free. You'll get them the day before they're released to the public. You get access to our monthly Zoom meet and greet, happy hour, cocktail, mocktail calls where you can talk to me.
Those are
Harry.
fun. Those are fun. Can't wait for the next one.
And also like pre-sale tickets if we have live events, stuff like that. Our gala that should be coming up here in a few months. You'll get invites to that, first dibs on that. So again, that's patreon.com/aisle45pod. Harry, Judge Ho did what I was hoping he wouldn't do.
Yeah.
But what we figured he would do. He followed the advice of the amicus curiae he appointed, Paul Clement, and dismissed the charges, all of them with prejudice, so they can't be held over his head and brought again. So let's read from Judge Ho's ruling here. He said, on February 14th, happy Valentine's Day, the Department of Justice filed a motion seeking to dismiss without prejudice the indictment against New York City Mayor Eric Adams, pursuant to Federal Rule of Criminal Procedures 48A. Department of Justice's motion, that's Trump's motion, right, states that dismissal of the case is justified for several reasons, including because, quote, continuing these proceedings would interfere with the mayor's ability to govern, thereby threatening federal immigration initiatives and policies. A critical feature of DOJ's motion is that it seeks dismissal without prejudice. That is, the DOJ seeks to abandon its prosecution of Mayor Adams for now, while reserving the right to reinstate the case in the future. DOJ does not seek to end this case once and for all. Rather, its request, if granted, would leave Mayor Adams under the specter of reindictment at essentially any time and for essentially any reason. The court declines, in its limited discretion under Rule 48A, to endorse that outcome. Instead, it dismisses this case with prejudice, meaning that the government may not bring the charges in the indictment against Mayor Eric Adams in the future. In the light of DOJ's rationales, dismissing the case without prejudice would create the unavoidable perception that the mayor's freedom depends on his ability to carry out the immigration enforcement priorities of the Trump administration, and that he might be more beholden to the demands of the federal government than the wishes of his own constituents. That appearance is inevitable, and it counsels in favor of dismissal with prejudice. Notably, Mayor Adams has filed his own motion seeking dismissal with prejudice on other grounds, and DOJ has not opposed that motion, effectively waiving any objection to permanent dismissal of this case. The parties offer the court no basis to dismiss this case in a manner that would allow DOJ to reinitiate in the future the case, and the court declines to do so.
Yeah, what a ruling there. Various groups that have submitted friend of the court briefs urge this court to go further and deny the DOJ's motion altogether, arguing that the reasons DOJ has given to justify dismissing this case are unsubstantiated or contrary to the public interest. The court ultimately declines their invitation to deny the motion, but it concludes that many of their arguments have merit. Right? Like, DOJ's first asserted rationale for dismissing this case, that it has been tainted by appearances of impropriety, is unsupported by any objective evidence. Rather, the record before the court indicates that the U.S. Attorney's Office for the Southern District of New York prosecutors who worked on this case followed all appropriate Justice Department guidelines. There is no evidence, zero, that they had any improper motives. Indeed, DOJ's memorandum directing dismissal of this case took care to note that it did not call into question the integrity and efforts of line prosecutors responsible for the case or efforts of the U.S. attorney leading the office at the time of the memorandum.
Yeah. Okay. All right. So even though all of the arguments that I shouldn't dismiss these charges have merit, I'm still going to dismiss the charges. Okay. But he gives reasons. He says in DOJ's assertion that this case, which was brought 9 months before the mayoral primary election, somehow amounts to election interference, lacks any support in Justice Department guidelines or past practice. In fact, the timing of this case is entirely consistent with prior public corruption prosecutions. All of this suggests that the appearance of impropriety rationale is not just thin, but pretextual. And this is where I kind of have a problem with what Judge Dale Ho did here. I know a lot of people agree with his ruling, but if any of the reasons to dismiss are pretextual, or if the reason to dismiss is pretextual, then you're supposed to deny the dismissal motion under Rule 48A. That's why Rule 48A exists, right? And later on in the ruling, he goes into the history of 48A. He's like, before 48A, DOJ could just dismiss whatever case they wanted to give their friends and politically popular people a break. And that's why they came up with Rule 48A. Like, the court should have some say here because of the separation of powers. Now, he goes on to say, as for the immigration enforcement rationale, to the extent that the DOJ suggests Adams is unable to assist with immigration enforcement while this case is ongoing, such an assertion is similarly unsubstantiated. Indeed, shortly after DOJ made the decision to seek dismissal, and while the indictment was still pending, the mayor announced he would permit Immigration and Customs Enforcement to operate at the Rikers Island jail complex, an act that appears to be contrary to New York City law. In other words, the record does not show that this case has impaired Mayor Adams in his immigration enforcement efforts. Instead, it shows that after DOJ decided to seek dismissal, the mayor took at least one new immigration-related action consistent with the preferences of this administration. Everything here smacks of a bargain. Dismissal of the indictment in exchange for immigration policy concessions. So the whole appearance of impropriety thing is, no, that's dumb. You don't have any evidence. And the rationale that he won't enforce immigration policy that you want him to, also dumb. So those two shot down.
Yeah. And taking a step back from the particulars of this case, DOJ's immigration enforcement rationale is both unprecedented and it's breathtaking in its sweep overall. DOJ cites no examples, and the court is unable to find any of the government dismissing charges against an elected official because doing so would enable the official to facilitate federal policy goals. And DOJ's assertion that it has virtually unreviewable license to dismiss charges on this basis is disturbing in its breadth, implying that public officials may receive special dispensation if they are compliant with the incumbent administration's policy priorities. That suggestion is fundamentally incompatible with the basic promise of equal justice under law.
Okay, so everything sucks. Your reason sucks. This other reason sucks. And this other reason that you used is really insane, actually.
And it sucks too.
But he goes on. Ultimately, however, there are two reasons why these points do not support outright denial of a DOJ's motion to dismiss Adams' case. The first is that the court's principal role in deciding a motion of this nature is to protect the rights of the defendant, and denying dismissal of the case would not do so here. I guess what he's saying, and
you're hung up on that.
He kind of explains it later, is that if he doesn't dismiss the case, the charges are still hung over Mayor Eric Adams' head. Because they're there still. And I'm like, so TF what?
Yeah.
He committed the crimes. And if DOJ doesn't want to prosecute them, or if he does, I don't care if he's scared. Like, you should be if you're indicted on all these charges.
Yeah.
Just make them run out the speedy trial clock, which is what I wanted them to do. But he goes, the second and perhaps more fundamental reason is that the court, if it were so inclined, would have no way to compel the government to prosecute a case in circumstances like those presented here. And that's kind of where we were all hung up, right? Like, well, he can't make the DOJ prosecute the case if he denies the dismissal. But I still wanted him to go through the motions of having to run out the speedy trial clock.
Yeah.
Finally, it's important to clarify that the court's decision today is not about whether Adams is innocent or guilty. The court's decision is also not about, and the court expresses no opinion on, whether the case against Adams should continue based on the kinds of factors that a prosecutor might typically consider in bringing a case, including the strength of the case, the prosecution's general deterrence value, the government's enforcement priorities, and the case's relationship to the government's overall enforcement plan. So I'm not saying that you wouldn't win this case, DOJ, if you prosecuted it. I'm not saying the case isn't strong. I'm just saying that I can't make the DOJ prosecute this. They're going to run out the speedy trial clock and dismiss with prejudice. In fact, there's one other case in the history of this court where they did this. And in that case, the judge actually denied dismissing the charges and forced the DOJ to run out the speedy trial clock. So I'm not fully convinced by his arguments because he says it's not in the public interest to go about it this way because it would take, another 70 days. And in that one case that happened in the district, like it was a year later and they ended up dismissing with prejudice anyway. So why not just do it now? And I'm like, because I want you to go through the hearing process I want all those amicus briefs to be heard. I want the public to know what was in the memo that Emile Beauvais sent to Danielle Sassoon beyond what she wrote in her letter was in the memo. I want to know what were in those meeting notes that Emile Beauvais...
you want to get inside of what is actually, you want the details of this shit.
I think that's in the public interest.
And that's what we're being robbed of, I guess, with this decision right here, not being able to see, oh, shit, he did what? Like, yeah. I get it. That makes sense. But I'm thinking about this in a bigger picture. And as, we're reading the opinion the opinion of the judge in his ruling, I started thinking about the precedent that this ruling is going to set, or it has set now. And just thinking about early on in the, it's still early on, but I'm talking early on in January when Donald Trump was saying, and his administration was saying, listen, if these governors aren't going to do what we tell them to do, then they will come after them too. And I'm wondering, is this, I just thought about in Illinois with J.D. Pritzker was saying that, he wasn't going to go along with this BS, administration.
Right, we're a sanctuary state.
Yeah, we're a sanctuary state. So wondering, what if bringing charges against them, that's all I started thinking about, like bringing charges against governors and, other mayors in other states. Does Dale Ho, with this ruling, did he foresee that and try to rewrite that ruling? Do you think this is the last we hear of, maybe with Eric Adams, sure, but this going down this road, dismissing charges or holding that above your head saying, hey, play ball or we're pressing charges against you. Do you think this is the last time we see something like this in the next 4 years at least?
Nah, I don't know. It's hard to know because in order to get charges, you have to have like good crimes and a grand jury has to return a true bill.
Well, yeah.
And then you got to survive pretrial motions to dismiss. And then you got to survive the trial. And then you got to survive the appeal. And, for him to come and bring charges against J.B. Pritzker, he probably isn't going to be able to. He couldn't even get charges to stick on the guy who shook Nancy Mace's hand too hard.
Yeah.
So like back when he was trying to indict Andy McCabe during the first Trump administration, and like he went to like a couple different grand juries and couldn't get Bill Barr couldn't get an indictment back, and he was like, "God damn it!" Like he was all mad.
Mm-hmm.
You're supposed to be able to indict a ham sandwich. And so,
that is right. I remember that.
Not looking very good. Right. Yeah. Because to bring an indictment, all you need is, I think, probable cause.
Yeah.
Which is a low standard. But you aren't allowed as a prosecutor to bring a case unless you are certain that you can win, you can obtain a conviction beyond a reasonable doubt and maintain it on appeal. So those kind of ideas sort of butt heads. But there are, like we saw John Durham bring charges against Sussman from Perkins Coie, I think, and to be and ended up losing because he couldn't obtain a conviction. And he was supposed to like really think long and hard about that, and he didn't. But he got the indictment because indictments are easier to get. But I think what the judge is saying here basically is like, look, I don't want the government to hold any charges over this guy's head, and so it's going to end up being dismissed with prejudice anyway. So I'm going to take Paul Clement's advice and just dismiss with prejudice, which is what you and I figured he would do, but man, I really wanted those hearings, and I really wanted him to.
You wanted that information in it. You
follow the rules of 48A. It exists for a reason. If this kind of pretextual BS is supposed to be one of the reasons that the court has a say in this at all, it's one of the few checks that the judiciary has on the executive branch. Use it. But I have an unpopular opinion on this. I know Andrew Weissman thinks that this is great, and Mimi Rocha thinks this is great, but mainly because it vindicates Danielle Sassoon and the 7 other people who resigned in protest about dismissing these charges, because they said there was nothing wrong with it. There's no impropriety in this case.
Yeah. It kind of makes them, hey, I was right, kind of like I told you so kind of moment. And you know what? Actually, I was just thinking related but unrelated. The DOJ, I think has been the defendant more so than the prosecutor in majority of the cases during this administration. And that's not a good sign. I mean, where the DOJ, the Department of Justice, the lawyer for the American people, is the defendant. That's not how many. I would love to. I mean, it's impossible to count how many cases are open and going. I'm sure they have people versus state, blah blah blah. Mm-hmm. But I mean, they are on defense a lot.
Mm-hmm. And it's weird. That's the weird whiplash for people who've been reporting on like the Jack Smith stuff. Yeah. The government's always like the good guys, right? When you say the government filed their motion today, you're like, oh, right on. I want to see what it says. But now it's the government filed its motion.
Hell.
Yeah, it's like, oh, jeez, what does it say? And that those lawyers that were arguing on behalf of Trump's Department of Justice in the case of Abrego Garcia, the guy Maryland father who was deported to Seacoast, he's put them on administrative leave because they admitted in court, like, we can bring him home. It's totally easy to bring him home, and we still have they're in El Salvador, but they're in our custody technically. And that really upset.
That's going to be hard for them to overcome, though. Mm-hmm. The DOJ, it's going to be hard for them to overcome that because you have one of your lawyers saying that on the record. Mm-hmm. And now any defense lawyer is going to be like, wait, their own attorneys admitted, blah, blah, blah. So, I mean, man.
Yeah, it's not a good look for them.
Didn't Trump appeal that to the Supreme Court, by the way?
He just did, yeah. And Abrego Garcia's lawyer has already responded, even though they had until Tuesday at 5. Keep in mind, we record this Monday. Yeah, he's like, flipping, make it rain with my response. I've got it right here for you. Yeah. But they paused indefinitely. The Supreme Court indefinitely paused his return so they can further review it. And we'll see if Roberts joins the liberals and where Amy Coney Barrett comes down on it. But we'll keep everybody posted. All right. We've got a couple of stories about, first of all, Cathy Harris and Gwen Wilcox from the NLRB and the MSPB. And then, of course, we've got a couple of January 6th stories, one where their unrelated case was dismissed and one where their unrelated case was not. And we'll go over those because there's no consistency anymore anywhere until things get up to the Supreme Court. But we have to take a quick break before we get to any of that, so stick around. We'll be right back.
All right, y'all, we are back. Now, the big news this week is the lawsuit filed by Cathy Harris and Gwen Wilcox after Donald Trump fired them from the multi-person boards, the National Labor Relations Board, and the Merit Systems Protection Board. According to the law, the president can't fire people in these positions without cause. But Donald Trump sent them both emails with one sentence saying simply that they were fired, like his days on The Apprentice, you're fired, with no reason given. Both Wilcox and Harris sued, rightfully so. The district courts ruled in their favor, rightfully so, returning both of them to their positions. their cases were consolidated, and then the appeals court, which had 2 Trump appointees on the panel, overturned the district court and refired them both while they waited for the merits of the case to play out.
Yes. So this is a firing, rehiring, refiring, possibly rehiring, rehiring. So together, Wilcox and Harris filed for a rehearing en banc, meaning they wanted all the judges on the D.C. Circuit Court of Appeals to consider their case instead of just the 3-judge panel that ruled against them. And on Monday, very quickly, the D.C. Circuit Court of Appeals voted 7-4. Guess how many Trump appointees are on the on the court?
I was just about to say, is it 4?
It's 4. To set aside the ruling of one of its 3-judge panels, which allowed the firings to proceed despite laws saying the officials can be dismissed only in cases of inefficiency, neglect of duty, or malfeasance in office. So this is from that ruling. Upon consideration of the petitions for hearing en banc, which include motions for en banc reconsideration and vacatur of the court's March 28th, 2025 order, that means to overturn it, granting the government's motion for a stay pending appeal, and the combined opposition thereto, which includes a request for a 7-day stay if the motions are granted, it is ordered that the motions for en banc reconsideration and vacatur be granted, and the government's motion for a stay pending appeal be denied.
They invoked the doctrine that Justice Clarence Thomas has been trying. They invoked the doctrine that Justice Clarence Thomas has been trying to get rid of for a while now. Humphrey's executor. In Humphrey's executor v. United States and Weiner versus United States, the Supreme Court unanimously upheld removal restrictions for government officials of multi-member adjudicatory boards, while 2 laws governing removal restrictions for single heads of agencies exercising executive policymaking and enforcement powers have been held unconstitutional. The Supreme Court has repeatedly stated that it was not overturning the precedent established in Humphrey's executor and Weiner for multi-member bodies.
Yeah, so basically that's the en banc panel writing for the majority saying, hey, the Supreme Court has already ruled that heads of agencies, laws that prevent the president from firing heads of agencies like Hampton-Dellinger are unconstitutional. But Humphrey's executor is still in place. The Supreme Court was adamant about it. They said that law, we're not overturning that. We're not overturning Humphrey's executor, which says, people on multi-member bodies like National Labor Relations Board and Merit Systems Protection Board, those laws are good. They're not unconstitutional. They've said that multiple times. And so that's why the appellate court is like, I don't know what the 3-judge panel was thinking, but we actually have to follow the law. And according to the Supreme Court, Humphrey's executor, while it may be on the brink of extinction, is still the law. And so we return them to their jobs. Go. Peace be with you. The ruling continues. The Supreme Court has repeatedly told the courts of appeals to follow extant Supreme Court precedent unless and until that court itself changes it or overturns it. If a precedent of the Supreme Court has directed application in a case, lower courts should follow the case which directly controls, leaving to the Supreme Court the prerogative of overruling its own decisions. So we're just the appeals court. We can't overturn what the Supreme Court has said, and the Supreme Court, like I said, still has Humphreys in place still. The Supreme Court and their repeated and recent statements that Humphrey's executor and Weiner remain precedential require denying the government's emergency motions for a stay pending appeal. The government, in fact, has acknowledged a lack of clarity in the law. In addition, at both parties' request, the court has set a highly expedited schedule for the merits of these appeals that will allow the case to be resolved in short order. We hereby vacate the March 28th order, staying the district court's final judgments and permanent injunction in these cases in light of the precedent in Humphrey's executor and Weiner concerning multi-member adjudicatory bodies. The government's motions for a stay pending appeal are denied. The government has not demonstrated the requisite strong showing that it's likely to succeed on the merits of these 2 appeals, at least as it stands now, right? The Supreme Court could totally vacate Humphrey's executor. They've been wanting to do it for a long time. Like you said, Harlan Crow.
Harlan Crow, yeah.
So, but as it stands now, we have to follow this because the Supreme Court says so.
The court then lists the 4 dissenting judges: Circuit Court Judges Henderson, Katsas, Rao, and Walker dissent from this order, and they would also grant the government's request to stay this order for 7 days to permit the government to seek relief from the Supreme Court. Separate dissenting statements of Circuit Judges Henderson, Rao, and Walker are attached. Circuit Judges Henderson, Katsas, and Walker joined in the statement of Circuit Judge Rao. Circuit Judge Henderson joins in the statement of Circuit Judge Walker. Yes. For the little bit of this judge agrees with this part of it, that judge agrees with this. It's just a mess. Lot. Yeah, it's right. We joined in with this statement of judge. Yeah, so
they all joined in, but somebody wanted to say something else, and then some other judges were like, "I want to say that too.
I want this have my name attached to it."
Me too. So basically, Henderson dissents because she says only the Supreme Court can decide this, and the whole en banc shebang just delays it. But you still have to maintain the status quo. Rao dissented because she thinks the president's too powerful to be bound by the law. Again, doesn't address the fact that the Supreme Court still recognizes Humphrey's executor. And Katsas, Walker, and Henderson join her in that. And Walker and Katsas dissent because they think the district court and the en banc ruling read Humphrey's executor too broadly. But they don't explain how, because there's really only one way to read it.
It's only one way to read it, you know?
Okay, you 4 weirdos.
Political rights. The ruling means that Gwen Wilcox, a member of the National Labor Relations Board, and Cathy Harris, a member of the Merit Systems Protection Board, can return to their previous roles for now, unless the Supreme Court steps in. The boards are crucial overseers of employee grievances in federal government and private sector, and without the Biden appointees, they lacked a quorum to conduct business. The Trump administration is virtually certain to ask the Supreme Court in the coming days to take the case on an emergency basis and promptly put the 2 officials out of their jobs again. The open question is whether the justices will step in to do so or allow the appeals court process to play out fully to a final decision before the high court takes up the case.
Oh, who knows?
They are getting their money's worth. I tell you what, the judges are definitely earned their paychecks this during this administration. Man.
Yeah, they really have. And, in some cases that's before the Supreme Court, like, we were talking about in the first segment, the Supreme Court said, no, hang back on returning the Garcia, to the United States. Hang back on that. So they have granted some stays and sometimes they haven't. So we'll see what they do in this case. We'll follow it and we'll bring you the information as it happens. But yeah, those 4 judges.
Unbelievable.
It's like Twister. It's like Judicial Twister.
Now, explain to me real quick, and maybe for some of our listeners. So this was a 7-4 ruling. So this is an 11-judge panel right here. Mm-hmm. What authority were they convened? And was this just another appeal that the 3-person panel, took it up? Is it saying, hey, we want all of these justices to hear the case? Or is just, how did they get this before that panel of 11 and didn't have to just accept the ruling of 3?
So the appeals process, generally, you go to the district court. Let's say I'm Cathy Harris. I go to the district court. I win. I get my job back with an injunction or a restraining order.
Okay.
And then Trump's mad. He appeals to the appeals court. When you first go to the appeals court, you get a 3-judge panel randomly assigned.
Okay.
And what happened in here is the 3-judge panel said, nope, Cathy Harris, you're out of a job again. Now I, Cathy Harris, I have a couple choices. I can go straight to the Supreme Court, or I can get an en banc ruling, an en banc rehearing, where I say, okay, 3 judges, that's cool, but I'm gonna ask the entire appeals court bench what they think. So that's when they all come and weigh in, and so it's a step between the appeals court and the Supreme Court.
And the Supreme Court
is to have an en banc rehearing, and Trump would use it a lot to delay, processes because it's another step in the process before you get to the Supreme Court.
Yeah.
But here, it's nice to have a good, solid en banc ruling before you go up to the Supreme Court, especially if it didn't go your way in the first place.
Got it. And especially thinking if you have a liberal majority, 7-4 in this particular circumstance. So
yeah, in this court.
That's interesting. That's interesting.
Yeah. All right, everybody. We're going to go over some January 6th extracurricular cases.
Extracurriculars.
Pardoned January 6th defendants. Some of them like to commit other crimes. And we'll talk about a couple of those, but we have to take another quick break. So stick around. We'll be right back. Hey, everybody. Welcome back. All right. Time to thank some of our Hall of Fame patrons. We're divvying them up across the month now. So Hall of Fame patrons, extra special patrons who I believe contribute $10 or more. And that's Ren, Special K Kaido, Rose Flaherty, Mitchell, Je Suis Fatigue, Dr. David in Brooklyn, skintwalletsusa.com, Scott Gregis, Deborah Kirby, and Patty B. Thank you, Hall of Famers. You make this, the entire show happens because of all y'all, our new patrons and our Hall of Fame patrons. We really appreciate you. All right, next up, let's check in on some of the unrelated extracurricular crimes committed by pardoned January 6th defendants. This is from Cheney and Gerstein at Politico. A federal appeals court has rejected Trump's Justice Department claim that Trump's pardon of crimes related to January 6th is so broad that it sweeps in convictions for illegal possession of weapons 5 months later. In a ruling Wednesday, the D.C. Circuit Court of Appeals, in a split panel, 2-1, this is the 3-judge panel, not the full en banc.
Yeah.
In turning down Kentucky resident Dan Wilson's bid to avoid reporting back to prison this week to serve the remaining time on his 5-year sentence of charges possessing an unregistered firearm and being a felon in possession of a firearm.
This was a little bit of good news, just seeing that type of, it sucks that it has to be heard anyway, but, here we go, due process, right?
Yeah.
Wilson was a member of the mob that stormed the Capitol and attacked me and my coworkers and was charged with multiple crimes related to his conduct on January 6th. During the FBI's broad criminal probe of the riot, investigators found an arsenal of illegal firearms at his home. The weapons were not connected to his involvement in the January 6th attack. Barring intervention from the Supreme Court or some further action by Trump, the appeals court ruling seems likely to result in Wilson returning to prison on the weapons charges. His lawyer, George Pallas, told the appeals court that Wilson was slated to report back to prison on Wednesday.
Bye. Yeah, Pallas told Politico he intends to appeal the ruling as far as the Supreme Court and may ask Donald Trump to issue a new pardon to stave off Wilson's return to prison. Quote, by again pardoning Wilson, he will show the courts that he has the upper hand. That's what Pallas said. Lamenting attempts.
Small, his hands, that small upper hand.
Tiny upper hand. Pallas said he was lamenting attempts by judges to second guess President Trump. We're reading the words that he wrote in his pardon. We're not.
Yeah, y'all are implying stuff that's not even there.
So the panel's majority concluded that the plain terms of Trump's mass pardon included only crimes directly connected to the attack on the Capitol, not those discovered by happenstance during the investigation on the riot. The ruling split the 2 Trump appointees on the panel. So 2 of the panelists on this, 2 of the judges are Trump appointees, Greg Katsas and Naomi Rao. Katsas joined Obama-appointed Judge Cornelia Pillard in taking a narrow view of the pardon because Rao always sides with Donald Trump.
Always. Rao dissented, questioning whether judges have the authority to interpret presidential pardons and suggesting that the court should defer to the Department of Justice about their scope. But then at the Department of Justice, this is ridiculous. They absolutely do. The judicial branch interpret. Legislative makes the laws. If executive enforces, judicial interprets the laws. Like, oh, come on, this is 5th grade civic. Judge Rao. Shortly after Trump signed the clemency proclamation on January 20th, the Bureau of Prisons released Wilson. However, weeks later, the Justice Department argued that it was an error because Trump's pardon was narrow and should not be read to cover Wilson's gun offense.
Yeah, and if Rao had her way, that means that Wilson in 5 years could commit a crime, could murder someone.
Yeah.
And we shouldn't be interpreting Trump's pardon to not include that. What? The judiciary has no place to interpret that. It's actually really your exact job. Is to decide. That's
literally their job, is to interpret that,
Yeah. About 2 weeks after that, the prosecutors reversed course and said the pardon was meant to absolve January 6 defendants of a range of other crimes. So they went from one to the next and then changed their mind again.
Yeah.
And the appeals court decision is the latest judicial rebuke to the Justice Department's effort to expand the scope of Trump's clemency for a variety of January 6 rioters who were convicted of other crimes based on evidence discovered during the riot investigation. Trump has been reluctant to clarify the scope of his pardons, despite questions that have perplexed the courts. Really? Perplexed? I'm not perplexed. Are you perplexed?
I'm not perplexed.
The president could settle the issue simply by issuing new pardons for the additional crimes. But in the absence of further action by Trump, the courts have been working to parse the opaque language of his blanket pardon and consider the relatively thin precedents governing the way the courts interpret pardons. And honestly, I don't think it's opaque. And a Trump appointee on this three-judge panel, Judge Katz, said, no, it's clear. I'm not, this isn't obtuse.
Yeah.
It's clear to me.
You're making it a lot more complicated than it has to be. In recent weeks, several other January 6 rioters with separate charges or convictions have seen developments in their bids to deploy their pardons broadly. A federal judge in Florida agreed Wednesday to dismiss the case against Jeremy Brown, a retired Green Beret who was convicted of possessing classified information and grenades at his home. We're going to get into that case in detail in a minute, so stay tuned for that. The California-based Ninth Circuit Court of Appeals has resisted an effort by the Justice Department to drop the conviction of defendant Benjamin Martin, who possessed guns despite a history of domestic violence. The Richmond-based Fourth Circuit has pressed lawyers for Elias Constantinos, Constantines, and the Justice Department to explain why Trump's pardon should cover his illegal gun possession, for which Constantinos is currently incarcerated. I don't even care about pronouncing that guy's right. Like his name right, screw him.
Elias. A federal judge in Tennessee declined to expand Trump's pardon to cover Ed Kelly, who was convicted by a jury of conspiring to kill the law enforcement officials who investigated him. That's the guy who tried to shoot up the FBI headquarters there in Tennessee. A judge in North Carolina agreed to postpone the criminal trial of David Daniel, who's facing charges for possession of child pornography that he says should be covered by Trump's pardon. Notably, the Department of Justice has argued that Trump's pardon, despite extending to many unrelated crimes, was not intended to cover the crimes of Kelly and Daniel. So they're drawing these arbitrary lines you and I have spoken about. U.S. District Judge Dabney Friedrich, a Trump appointee who presided over Wilson's trial on both his January 6th and gun charges, expressed frustration and bewilderment at the Department of Justice's shifting and inconsistent positions as she took the narrower view of the pardon. So a Trump appointee, Judge Dabney Friedrich, she's with me on this. Like, why are you yes to Kelly and Daniel, but no to these? It makes no sense. In their opinions, both Friedrich and Rao suggested that Trump could settle the issue with a clarification, such as an additional pardon that makes his intent clearer, or to come out and say, no, they don't cover that. Just
simple.
But he's not going to.
He's not going to.
He enjoys the drama that he's created.
But also he's impulsive. So I actually see a world where, it's, anything morally, the right thing to do morally. I don't expect that from Donald Trump.
No. And I'm curious to see if he pardons George Santos, who's now the DOJ is recommending 87 months in prison.
Yeah.
But Santos pled guilty. It's not like he was convicted by a jury.
Yeah. He took a plea deal.
Yeah, he took a plea deal down to 2 of the 23 felony counts. And that's still over 7 years in prison.
Damn, that could have been Eric Adams.
I know. From the sentencing guidelines. But Trump could swoop in and pardon him. But is he any good? Does he give anything to Trump? Like helping out the January 6th defendants, the true patriots, like that helps his base. Like that helps him be more popular with the jerks, and it helps recruit extremist groups like the Proud Boys and the Oath Keepers and the 3%ers. There's
some return on investment there.
Right. But what can George Santos offer Donald Trump? I bet he's trying to come up with lists. To say, hey, guess what? Here's what I can do for you. I can bring you on my podcast, and I can.
I'll blow glitter up your ass. You know,
he has no money.
Yeah,
I mean, that's what he was convicted for, right?
Yeah.
Lying about the fact that he had any money. So I don't know that he can do any favors for Donald
And
Trump.
didn't we cover earlier, early in the year or maybe late last year, Santos was requesting a delay.
Yeah.
So he could do his cameos and stuff to make his podcast to make money for that. Yeah.
He's like, I got to pay restitution and my podcast is starting to take off. So can you, you delay my sentencing till August? And the judge was like, I'll give you till April 25th. So
he's
going to be sentenced here. Yeah. In just a couple short weeks.
Yeah.
Maybe we'll get a little good news or maybe Trump will swoop in and pardon him.
Or maybe he'll swoop in. Who knows?
Either way, we'll let you know. All right. We got that tiny bit of Rudy news. Plus, we're going to go into detail on Jeremy Brown's case a little bit as we promised. But we have to take one last quick break. So stick around. We'll be right back. All right, everybody, welcome back. As promised, let's dive into that other January 6th case for unrelated crimes, the case of Jeremy Brown. This is from Law and Crime. A January 6th defendant and Oath Keepers member from Florida who was linked to an explosives-laden RV that was allegedly brought into the D.C. area had a series of separate convictions for possessing illegal firearms and U.S. Army grenades, officially vacated and dismissed by a federal judge Wednesday in the Sunshine State as part of Trump's January 6th pardon order. So he got his case dismissed.
Yeah, this is wild. Jeremy Brown, a former U.S. Army Green Beret who was given a 7-year sentence for the weapons and grenades case, gained support from Trump's Justice Department in late February, with federal prosecutors telling U.S. District Judge Stephen Merriday that based on consultation with DOJ leadership, it was the position of the United States that the offenses Brown was accused of, including possession of a modified AR-15 short-barreled rifle and a sawed-off shotgun, both unregistered and owned illegally, were intended to be covered by Trump's pardon order. Wow.
Merriday, Merriday's George H.W. Bush appointee, he agreed. And on Wednesday, he vacated Brown's convictions with an official order in the Middle District of Florida. The move came after the 11th Circuit Court of Appeals relinquished jurisdiction in March to the District Court to consider and rule upon the United States motion to vacate and dismiss the explosives and gun convictions against Brown, who was sentenced in 2023 and released from prison in February. Quote, the United States motion is granted, the judgment is vacated, and the second superseding indictment, and derivatively, perforce the pardon, both the superseding indictment and the indictment are dismissed with prejudice. That's what Merriday said. The clerk must close the case.
Man, how disheartening.
Yeah.
That's wow. For his January 6th case, Brown was accused of unlawfully and knowingly entering and remaining in a restricted building and grounds at the U.S. Capitol, according to court documents. He was charged in Washington, D.C., federal court with misdemeanor trespassing and disorderly conduct, with photos showing Brown donning military gear. So let me just stop real quick. And this is what people, this is what the narrative would happen in everybody saying that these people who were just trespassing around the Capitol were serving months and years in jail for just trespassing. No, nobody was for solely that. Those people were given, probation and, restitution, $500 fines, time served. The people that were in jail, like this individual we're talking about now, Mr. Brown, was in jail because of all the other stuff, an explosive laden RV, and a sawed-off shotgun, and an AR-15 modified. That's the people that were in jail. So, yes, his charges stemming from January 6th were because of, trespassing and blah, blah, blah. But the time he was in jail because he had a bomb-laced RV and all these guns. So that's the part that makes me so upset. Like, oh my gosh, they were arresting people for just walking around. No, that's not what happened.
No.
But I digress.
And that was true. Well, all these beautiful patriots, they were just there loving everyone, and it was hugs and peace and kumbaya. And it's like, no, the people who were in prison were the ones in the riot gear that were beating up cops and with weapons. Sometimes makeshift, some had guns. Like, they're just trying to whitewash.
Yeah, the grandmas were not sitting in prison. They got fines and, like you said, time served and everything like that. But I digress. In Florida, Brown was found guilty after a jury trial in December of 2022 of possession of unregistered short-barreled firearms, possession of unregistered explosive grenades, improper storage of explosive grenades, and retention of classified. That's what he was in jail for.
Mhm.
Retention of classified information.
Yeah, but they found it when they were looking for
trespassing.
They found it when they were looking for January 6th stuff, so it doesn't count.
Oh my gosh!
According to evidence presented at trial, the FBI executed an arrest and a search warrant at Brown's residence in Tampa on September 30th, 2021, and found an unregistered AR-15 style rifle modified to have a 10-inch barrel in his bedroom. Agents, that's where I keep my modified AR-15 short barrel guns, as you know, under my pillow. Agent also allegedly found a sawed-off shotgun on a couch beside inside Brown's recreational vehicle, which was parked near his home. I bet he paid more for his RV than Justice Thomas paid for his.
I guarantee you he did.
Quote, inside a briefcase next to the shotgun, agents found a classified trip report that Brown had authored shortly before he retired from the Special Forces. That's what prosecutors said in a press release in April 2023, and went on to say, inside the bedroom of that same RV, agents found an ammunition vest containing 2 M67 fragmentation grenades hidden in the pockets. U.S. Army records confirmed that the grenades had originally been in the possession of the U.S. Army. So he stole grenades, he stole classified information, he had sawed-off shotguns. All of that was found in a search, and because they got the warrant based on his being at the Capitol on January 6th, this G.H.W. Bush judge decided that this is included in the pardon.
I mean, he could have just dropped it in a Signal chat, and I guess this would all go away, right? Prosecutors, however, didn't provide a specific reason in their February notice of filing Brown's certificate of pardon for why his weapons and explosive convictions were being thrown out. Just that it was based on consultation with Department of Justice leadership.
Oh, so they didn't even have an argument.
They didn't.
They were just like DOJ said.
We just consulted and they said, yeah. Attempts by Law and Crime to reach the DOJ for comment on Wednesday were unsuccessful.
Oh, good
so
Lord.
This just goes on to, it just continues to paint the picture of the type of people that were there, the type of people that are back on the streets. Without any type of rehabilitation or, people get sentenced and held accountable to serve as a deterrent of their crimes. And there is, little to none of that being served right now. And it just goes on to, like you said, highlight, hey, these are the very fine people that Donald Trump loves and thinks the world of. So,
yeah. And if this goes up to the Supreme Court, which it won't, because nobody's going to, I don't think anybody, the DOJ nor the defendant are going to appeal this, right?
Yeah.
But, if the Ninth Circuit, I don't think there's going to be a contradictory finding from a different circuit from the DC Circuit Court in the previous segment that we talked about. Because if in these other lower courts where where judges are actually dismissing these extracurricular charges, nobody's going to fight that. Nobody's going to appeal that. Right? The defendant's not going to appeal it. The DOJ is not going to appeal it. So I don't know that this will necessarily be heard by the Supreme Court unless it's something like what's going on in the DC Circuit, where they have said the guy has to go to jail. And if that goes up to the Supreme Court and the Supreme Court says, no, you're right, the pardon doesn't cover this, nobody's going to bring back these other cases.
The only people that care to bring this to the Supreme Court to get appealed aren't in positions to.
They aren't gonna. It's like Eric Adams and the DOJ. That's why the court had to hire that other guy to come in and be an adversarial voice. Like
everybody here listening right now thinks it's crap and it should be appealed, but we don't have the standing to appeal anything. That's why DOJ is, like you said, on defense more so than offense. Now, so this kind of sucks,
It does. And I'm sorry, my friend. I know this is bullshit.
It's total bullshit. But can we move on to something else, though?
Rudy.
Can we move on to something else as we talk about bull? Let's talk about our good old friend, Rudy.
A message to you, Rudy.
Listen, JVL at the Bulwark writes, because God has a sense of humor, last Thursday, Newsmax rang the bell to open the New York Stock Exchange. No, really. In case you missed it, Newsmax did an IPO on Monday. The stocks debuted at $10 a share and jumped to $82 in its first day of trading. I know what you're thinking. That's insane, right? Like,
right.
This is crazy. $82 a share from 10? Newsmax loses money every quarter and has very little revenue. It has an ongoing legal exposure. The linear cable industry, of which it is part of, is in a death spiral.
Newsmax CEO and the famously sober lawyer, Rudy Giuliani. Ring the bell at the New York Stock Exchange, April 3rd, 2025. Moments later, the Dow dropped 1,500 points. The S&P 500 lost 4%. The NASDAQ composite slid 5%. But it didn't stop these brilliant capitalists from celebrating. Anyway, on Wednesday, the stock market crashed. Newsmax closed at $52 a share. And yet there was CEO and conservative mocker Chris Ruddy on the floor of the New York Stock Exchange, grinning as he rang the opening bell. It's the perfect distillation of late-stage capitalism. A conservative grifter, a guy who first rose in right-wing circles in the 1990s by spreading grotesque conspiracy theories about tragedies like the suicide of Vince Foster and the crash of TWA Flight 800, becomes a paper billionaire by shamelessly propagandizing for Trump. The market rewards him, even though his company is a money loser in a dying industry. His network spends the week trying to justify the economically illiterate tariff scheme, which is blowing up the global economy. His stock crashes, and on the day of reckoning for Trump's tariffs, as trillions of dollars go up in flames, the business establishment affords this man the honor of opening the market and starting the conflagration. It's so well written.
So it is so well written.
It ends with "Good luck, America."
Good luck, America. I mean, it sucks that we're chuckling at this because it's like, wow, you couldn't make this stuff up if you tried to. People are losing everything as a result of everything that's going on with the stocks and
what was Rudy doing up there with Newsmax, man? Was he like, hey,
is this his new gig? Is he about to be, could this be a start of something bigger, Allison?
I belong here because we both lost defamation cases to the tune of tens of millions of dollars.
Wouldn't it be interesting, though, if in about a week or so they announced that Rudy's going to be a contributor on Newsmax or something? I mean, God, wouldn't we love, that would be great. We would have unlimited Rudy news if that was the case. But, how fitting for two losers, Newsmax and Rudy and everything, to be opening the bell on one of the darkest days in our stocks or our what do they call it, the Dow and S&P's history.
The stock market, yeah.
The stock market's history. Two people, Rudy and the entity of Newsmax.
Yeah.
How fitting, right?
Yeah. And I was like, oh, who's going to open it Monday? It was the president of Travelers Insurance that rang the opening bell Monday. And if I'm looking right now, as of recording, it looks like Dow closed about 400 down. Looks like possibly 1%. And so not as much of a bloodbath as we were expecting, as the futures indicated on Sunday night. But I think it's because a bunch of conservative folks and Besant were like, hey, we're going to put a 90-day pause on tariffs. And then there wasn't a 90-day pause on tariffs. And the market was just like, so the market crashed. It was down like 1,600 points. And then they said 90-day pause on tariffs because we got some beautiful deals coming up with all the countries and the penguins. And then the market shot up like 600 points, like an 8% swing in like fucking 2 minutes. And then Caroline Levitt said, no, there's no pause. And it went back down again a little, but it kind of held, like the whole market was like, what is it?
Don't nobody know what's going on right now. Can I talk to an adult, please?
Scheme. I think it's a stock scheme.
You know what? This is how it happens, AG. I mean, this is how rich people get rich and stay rich. And people that are aspiring to get rich through, stocks and, I'm not going to call them schemes or nothing like that, because stocks is, there's definitely a way to sustain your life.
A lot of our 401ks have stocks. A lot of pensions
are
based on stocks, even though Sean Fain from the United Auto Workers Union is like, quit crying about your 401ks. The stock market's just for the rich people. Like 57% of the United Auto Workers pension is in stock.
It's in the stock, exactly.
Yeah.
So, that's a little disheartening to hear something like that, but yeah, but this is I agree with you that this is a scheme, to help rich people get richer and everything like that. Everything goes down, they buy it low, And then next thing you know, in 10 years, you invested in whatever company, and now it's worth 100 times its value 10 years, 15 years later.
Yeah. Yeah, we'll see. I've been predicting that maybe by the end of the week, there will be many beautiful deals that the president has cut with these countries, which don't exist, right?
China doesn't look like they're playing around. I mean, none of these countries actually.
He's going to say, oh, we've gotten calls from many leaders. They had tears in their eyes. They love me. And so we're going to do some negotiations. And in the meantime, we're going to pause the tariffs. The stock market's going to go back through the roof again. And then all of his rich buddies are going to sell. They're shorting the stocks right now. I think that's just my 2 cents. And Trump is telling everybody when those announcements are going to happen so that they can, it's market manipulation. Of course, there's nobody at the SEC right now. So nobody can look into it. And the president's immune anyway.
Yeah. Unbelievable, but here we are.
Here we are. All right. Well, we didn't get all the things we wanted. We got some of the stuff we wanted. And it's gonna be that way, I think, for the foreseeable future. But thanks again to all our new patrons and all of our Hall of Famers.
Thank you.
Harry, thanks to you. I'm still flying high from Wisconsin, and you had a big part of that.
Oh, my God. That was so good, man.
It was just so good. So thank you for that and all the work that you did, all the times you traveled up there, flew into Chicago, drove an hour to Wisconsin, flew back, met with Sherrod Brown, and just all
tons of work. So and there are tons of motivated people. And that brings me to this. I want to end this on my closing note. But look, how do we stop Donald Trump? Like outside of, there's no legislation, there's no impeachment, like none of that stuff's going to happen. It's going to take a few Republicans that have a breakthrough of moral courage, right? And right now, that's what the only thing that's coming now. In 2026, how do we stop Donald Trump? We control one chamber of Congress. Whether it be the House, whether it be the Senate. Now, if you look, the House is obviously the easier one because every single person, 435 people, are up for re-election, and only 1/3 of the Senate is up for election. So, let's focus on winning this damn House.
3 to win.
Just 3 to win. We got to hold everything, and then we got to take over 3. So that should be the focus right now, because that's how you stop Donald Trump. Like, if you look, like Nancy Pelosi stopped everything that Donald Trump wanted to do during his first administration because she held the House in by a very slim majority. I mean, they were, was it +1 or 1 or 2? I mean, it was very small. I don't know the exact margin, but
she held that caucus together, man.
She held that caucus together. But that's what it's going to take. We have to hold one chamber in Congress, because if you look now, I mean, there's a lot of talk and, people are talking about how to circumvent these judges that are stopping Donald Trump. And that's having talks in the House of Congress. So if we American people who actually love our country can get one chamber back, and I think the House is the easiest one to do because all 435 people are up for re-election. That's how we stop Donald Trump in his last 2 years. Yeah.
So, and the numbers that we're seeing in these state house elections, the numbers that we saw in Florida, even though we didn't win Florida 1 or Florida 6, that the come and make them back 15, 22 points. The numbers that we saw in Wisconsin, 10-point win for, I know it wasn't a House seat or a actual Democrat, but somebody that the Democrats back. That is indicative of a pretty big sweep in the midterms. And remember, states run the elections. Not Donald Trump.
States run the election, not Donald Trump. And actually, somebody asked that while I was out there on the ground. What if Donald Trump comes in and stops the counting of the election? I was like, look, he has no authority in Wisconsin.
He'll try. He'll definitely
try. But like the states run it. The Secretary of States, whoever certified to vote, your attorney generals, your board of elections. Those are the people that are in charge in the state, not Donald Trump. So have a little bit of comfort in that.
Yes, indeed. Very well said, my friend. And everybody will be back in your ears. If you're a patron, we'll be back this weekend with a bonus episode. And otherwise, we'll see you next week on on cleanup on aisle 45/47. I feel like I want to take the art and just like cross out the 45.
I think we can. I think a lot of people would like that. I've been seeing some of the comments like, is it now 47? Like,
yeah. We're still trying to clean up.
We're still trying to clean up 45. It's still a mess. Like, it's orange stains on the floor. Like,
all right, everybody. Thanks so much for listening. We'll be back in your ears. I've been Allison Gill.
Harry Dunn. Thanks, y'all.
Cleanup on Aisle 45 is written, researched, and produced by Allison Gill, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.